Good morning and welcome to the East Brandywine Township, Carlino East Brandywine LP preliminary land development application hearing for East Brandywine Township. We're going to pick up where we left off last week, but I do want to remind everybody the disrespect that's been shown during these hearings is unacceptable. And I was very, very lenient last week, and I regret today for allowing some of the nonsense to continue. So I want to remind everybody, we are up here for your service, everybody's service. And if an overruled or a sustained is spoken up at this podium by anybody sitting here, that's the end-all be-all. There's no argument, if we were in a courtroom proceeding, there would be contempt, and everybody here knows that. So let's please show some respect for the people who are up here trying to serve you guys as fair as they possibly can. I'm going to turn it over to Kristen Camp, and we'll continue where we left off.
Thank you. So I think we're picking back up with Andy Heinrich. Is that correct?
It is.
Okay.
Madam Solicitor, while Mr. Heinrich is assuming the chair, you brought to my attention the fact that on my paper index of the exhibits, number 11 is mismarked. It's marked 2000, where it should be 2018. I don't know what to call it, but the Avery index does have the right date. It is 2018 on the Avery index. And in addition, you have told me that there was an additional exhibit which you believe was denied, which I do not have marked as denied. Frankly, I can't speak to that, but the record will speak for itself.
Right. I had my notes indicated BVA 7, but again, the record will reflect that.
Wanted to
Thank you.
put it on the record. Thank you, ma'am.
And Mr. Heinrich, you're continued to be sworn from the last hearing.
Is there an exhibit book?
There's several.
He'll need the township exhibit book.
Right.
Mr. Heinrich, while they're giving you that, all of the questions I'm going to ask you are with regard to Township Exhibit 31, which is your December 7th, 2018 review of LTL's report. So if you turn to 31, that'll make it a little easier for you. Let me know when you're ready.
Ready?
First of all, I'd appreciate if you'd look at the first page at comment number 4. And your comment is actually labeled in bold response on the second page. And this comment is addressing section 399-81E. Is that correct?
Say it again. This section, yes.
And that's the section that addresses safe and efficient ingress and egress, correct?
Yes.
I read your response, and please feel free to read it to yourself. It appears to me that your conclusion is that LTL's level of safety in the review comment is ridiculous. Isn't that how you categorized it in the second line of your response?
The response stands for itself. The particular
Say it's ridiculous.
comment that they made, I
Objection.
think, is ridiculous.
Have you been advised by PennDOT that they actually required changes to the plan, to the HOP plan, because of the legitimacy of LTL's objection to the Route 322 ingress and egress?
On Route 322, yes.
Are you aware of any physical limitations stemming from the property itself which prevents designing a road satisfying the safety concerns raised by LTL?
That's an awfully broad question. Can you narrow it down a bit?
Do you know of any physical condition generated by the land itself as it sits that prevents designing a road that satisfies these concerns of LTL expressed in the original comment number 4?
Objection. We debated this time and again. The criteria that has to be, the criteria is not a blank piece of ground. It's, the criteria is with regard to this plan, with the road in the location it is, and the buildings in the location they are. I think that you directed Mr. Prince multiple times, Kristen, that type of question is not relevant.
Well, I
I
think
would like to speak to that.
I'm about to overrule the objection.
Thank you.
But I do want to say that I think if you could be more precise, because LTL raised several concerns about the design. So if you can be specific, he can address them line by, or concern by concern, rather than just generally.
Question wasn't general, madam.
The question was general.
The question was with regard to section 399-81E. That's what I'm questioning about. We're only dealing right now with that section.
Right, but there are 5 different concerns that LTL raised under that paragraph. So he may have a different answer based on each 5 of those points.
If he has that, he can say it. I'm asking him, and I will repeat it. Do you know of any physical problem caused by the property itself, as it stands, that would prevent designing a road that would satisfy these objections that LTL raised under 399-81E?
Objection again to the relevance of what
He's
LTL.
Overruled.
You've already overruled it, ma'am.
Answer the question, please.
Well, as I indicated, that's an awfully broad question. You specifically referred to Horseshoe Pike, so if your comment is specific to Horseshoe Pike, I think those changes have been incorporated as PennDOT has directed.
Do you know, okay, I understand what you're saying. So look at 4I, double I, triple I, I-4 and I-5, which do not involve 322 entrance itself. Do you know of any physical limitation with regard to the property as it stands that would prevent a road from being designed to satisfy the objections LTL raised as to those subparts?
Well, your question is too narrow in some respects and too overly broad in other respects. Number one, I'm not the designer, so the question is probably better directed to the designer. I just review the plan as presented to me. Secondarily, there are other factors that come into play with intersection design. So when you talk about physical, it's not just physical barriers or constraints that come into play. For example, and this is just one example, when we design for truck turns, what is the guiding dimension here? Is it the occasional truck or is it the occasional pedestrian? Because when you overly design an intersection to accommodate truck traffic, you also make the crossing longer for pedestrian traffic. So by designing something to accommodate that occasional truck, you may be making the intersection more unsafe for pedestrian traffic. So that's just an example. So your question focused on, as I understood it, physical. Physical is not the only determination here. But like I said, I'm not the designer, I'm the reviewer. So I just can review based on the plan that's presented to me. There might be other factors that I'm not aware of that could prevent the designer from designing a different way.
I apologize, Mr. Heinrich, I think I confused you. Let me try and simplify it. Do you know of anything, given the property as it stands today, and let me ask you, have you been out? Have you seen the property?
Many times.
Do you know of anything that prevents someone from, as you say, designing a road to fit on that property in a fashion that complies with the township ordinance?
Objection, asked and answered. That's the exact same question that Mr. Heinrich just answered.
Sustained.
It's not the same, ma'am.
It is the same. You've asked it 3 times. He gave you an answer.
Madam, then sustain the objection.
I did.
Okay. Would you turn to note 21, which is on page 3. Let me know when you've finished your response.
I'm sorry, my what?
When you finish reading your
Oh,
response to
okay,
yourself.
yeah, I'm done.
Okay. Will you agree with me that nowhere in that response do you discuss any physical hardship generated by the land itself that prevents the design of a road that conforms with the township ordinance?
Same objection I made before. Relevance.
Overruled. You can answer.
Well, if the discussion in there that we're creating just a road section that'll never extend beyond North Guthriesville Road or Horseshoe Pike, I think that's physical, but
Okay? You agree with me that if a road could be designed to meet that criteria, that is 350-33B, that then there would be no need for a waiver?
Objection, it calls for facts, it assumes facts that are not in
Overruled. He can answer the question. It's sort of a silly question. If it meets the code section, they don't need a waiver. So it's pretty obvious, but you can answer it, Mr. Heinrich.
well, if we have a blank piece of paper, perhaps.
I didn't ask you about blank piece of paper, Mr. Heinrich. I asked you,
Mr. Prince, let him answer it his way.
Your question is there anything that's physically preventing them? If you consider the buildings that are proposed to be built, that's physical. So are you speaking in terms of a blank piece of paper or with some buildings on the property?
Mr. Heinrich, since you're asking me, I'm asking you, if you take this property as it stands today, and I'm the designer, is there anything that prevents me from designing the road in a fashion that satisfies 350-33B and thereby eliminates the necessity for a waiver?
objection, asked and answered. He answered the question.
No, overruled. He didn't answer it with respect to this section, to this comment.
Again, with a blank piece of paper, a road could be designed, but then other things are compromised, such as spacing of signalized intersections along Horseshoe Pike, the ability to develop the property, the ability to obtain the right-of-way, perhaps, to build the road that might be conforming with the against the waivers requested. So there are other factors besides just the physical layout of the property that come into play.
Okay, I just want to make sure I understand your answer. So you're not saying that it can't be designed to eliminate the need of waivers. You're just saying that in contemplating whether or not it could be designed, you need to look at all these other factors. Is that right?
That's part of it, yes.
Okay. Move on to number 24, please. Now, if I read your response correctly, and this is with regard to 350-35D, you note the location of the proposed connector road and the need for the connector road to intersect North Guthriesville Road at a 90-degree angle has been deemed acceptable. Did I read that correctly?
Yes.
Would you please tell me who deemed the location of the proposed road acceptable?
I did on behalf of the township. PennDOT, when they approve a permit, will have done so as well. So far, there's been no objection to it, so,
Well, so far, there's been no approval of it either, has there?
but there's been no, the plans have been submitted to PennDOT on multiple occasions, and if it was unacceptable, PennDOT would have raised that concern long ago.
But there's been no PennDOT approval, has there?
Until the final land development, there will not be.
Okay. There were prior plans. Did you see any PennDOT approval of any of the prior plans?
As I just said, until the final plans, there will not be.
So the answer is no.
My answer is what I just said.
Okay. You will also respond with regard to this issue, that it's situated entirely within the state legal right-of-way and is therefore entirely under the jurisdiction of PennDOT. The granting of this waiver is acceptable, subject to the approval of PennDOT. Did I read that correctly?
Yes.
Are you familiar with Township Ordinance 350-26? And I do have a copy of it here to show you.
Not specifically, but
Would you please read out loud paragraph B that I've highlighted?
the standards and requirements outlined herein shall be considered minimum standards and requirements for the promotion of public health, safety, and general welfare.
Now, bearing in mind what that says, isn't any lesser standard, regardless of whether PennDOT approves, a violation of that section?
I object, I don't understand the question. Now, maybe Andy does, but I don't understand.
Well, Mr. Prince, shall and will, correct?
I'm sorry?
It stated shall, not will. I think you're intending that it says it has to be. Shall is intending,
No, it says shall be
right,
considered
but it
minimum
doesn't say
standards.
will.
I'm sorry?
It doesn't say will. It says shall. Factual?
Shall's mandatory.
I always had an impression will was mandatory.
No, shall is mandatory, I assure you. But that's a matter of law. I'm asking him the question, and he hasn't answered it.
Do you understand the question, Mr.
Repeat the
Henry?
question.
I'm sorry?
Repeat the question.
Sure. Isn't any lesser standard, regardless of whether PennDOT approves or not, in violation of 350-26? Which says that the standard that is set forth in the ordinance is the minimum.
I take it that PennDOT has jurisdiction, so regardless of what the standard is in the ordinance, PennDOT requirements supersede the ordinance.
Okay, would you please turn to number 23? Try and move this along. Now, that relates to 350-35C, and that's the 1,000-foot minimum spacing requirement between intersections along an arterial street, correct?
Yes.
Can you tell us briefly what is the purpose of requiring that 1,000 minimum foot distance between intersections?
I couldn't tell you. I didn't write the ordinance.
Well, I appreciate you didn't write it, but haven't you opined on the past about the need for the 1,000 foot and why it's important?
Not with respect to this. The only comments I've made is that the general rule of thumb is that traffic engineers desire to provide 1,000-foot spacing between signalized intersections.
Okay, and why is that?
To promote, when you have multiple signalized intersections, and in this case, they will be interconnected or coordinated, anything short of 1,000-foot spacing makes it more difficult to provide adequate coordination to traffic along the major street.
Okay, going back to this 350-35C in your response to number 23, are you aware of any study that's been submitted by Carlino as part of this plan application that demonstrates that this distance reduction would not endanger public safety?
A specific study for this specific requirement?
Yes, for this distance, the distance between, that you comment on, between the BBA intersection and the proposed Route 322 intersection for the shopping center.
Well, I guess the traffic impact study, if approved by all jurisdictions, would probably qualify.
Okay, you don't know of any other?
No.
Okay. Question. You do agree that the distance proposed between the Route 322 intersection and the BVA intersection is less than 1,000 feet?
The distance between those two intersecting driveways, roads, whatever you want to call them, are less than 1,000 feet, yes, but I'm not sure they both qualify as intersecting roads per se. One's a driveway.
And I think you agree, do you not, that the Carlino proposal, the entrance to Route 322, actually reduces the current distance by at least 75 feet, correct?
Reduces which distance?
The distance between Route 322 entrance as it currently exists and the BVA entrance.
Yes.
Now, as I read your answer, and you tell me if I'm wrong, it appears that you conclude that if PennDOT finds that the proposed separation distance is unsatisfactory, the solution that you perceive is that BVA should be required to terminate its right turn in, right turn out driveway that the board approved in 1995. Is that right?
Well, if it's considered a street,
Isn't that what you said, that BVA should have to terminate it?
if it's considered a street,
Isn't it Carlino's
under that,
response?
under your logic, if it's considered a street, yes.
Okay, so just so I understand, so as you said, under my logic, if it is a street intersection, then in order to approve this plan, BVA should be required to terminate its intersection. Is that right? I mean, that is what
I'm
you
saying-
said, right?
I'm saying it's non-conforming as well.
You're saying BVA, in order to approve this plan, should be required to terminate its intersection. Isn't that what you said in the note?
I'm saying it should be closed under those conditions.
Isn't it Carlino's responsibility to submit a conforming plan?
I'm not sure with the use of the word conforming in there, but it's Carlino's responsibility to provide a plan.
Conforming to the ordinances.
Well, subject to waivers, et cetera.
Don't you also indicate in your response that you find the granting of a waiver would be acceptable?
Yes.
Would you please show me where Carlino requested such a waiver? Would you like to look at the waiver list they submitted the last time? It's board exhibit, wait a minute, let me get the index and I can tell you. Council says 7. You want to look at exhibit 7?
Well, my response says if the granting of this waiver from the granting of a waiver from this section if necessary.
Yes. And I asked you, would you please show me where they requested a waiver?
If they didn't request one, then it perhaps is not necessary.
Or perhaps they missed it, huh?
Possible too, I guess.
Okay. Would you please turn to comment 26? Now, as I understand your comment, you're asserting that since the intersection turning movement counts were conducted in June of 16, before either the Maple View development or the proposed development across the street were underway, that the TIS should be okay. So My question is, did the June 2016 count address those two new developments that will exceed 300 units and entering an exit from 322 and will need to use the connector road to reach the shopping centers or to go north?
I do not recall.
Right. Isn't the consideration of those units a critical element of the TIS?
I wouldn't use the word critical.
How about important?
It could be important, but in terms of the TIS, there are other factors, there are other developments that were included that did not occur, and without going into a long, drawn-out discussion, unless you want me to go there, I believe that the traffic counts provide the information necessary to know that the design of the intersection is adequate.
Let me show you section 350-37 and ask you to read out loud the section that's highlighted in yellow.
The study shall include, but not necessarily be limited to, an analysis of expected traffic generation to, from, and upon surrounding roads within a radius of a half-mile from the proposed development site, particularly showing AM and PM peak hours of existing traffic flow during a normal business day in comparison with that which is anticipated after the proposed development is fully completed.
Does the current 3-year-old TIS comply with the requirements of that section?
In general, but there are specific developments, as you've indicated, that are not included.
You agree with me that Mapleview is within a half a mile of the proposed Carlino Shopping Center?
Most likely.
And the proposed senior citizen development right across the street is clearly within a half mile?
Correct.
And you'll agree with me, I hope, that 350-37 clearly requires an analysis of the expected traffic generation from both of those developments to be included in the TIS.
This ordinance does.
Okay. Let's turn to comment 31. Now, this is another radii issue, correct?
Yes. Corner radius.
I'm sorry, which number are you on?
31.
31. Your revised response, and it's with regard to 350.33B and C, noncompliance was to find it satisfactory because the connector road will dead end at North Guthriesville, controlled by a stop sign. Is
Hold
that
on.
essentially your
Excuse me.
justification?
Which comment are we talking about? I thought you said 31.
Oops. You're right, that's not 31. I'll bet it's 21. Let me see. Sorry.
I'm sorry, are we going back to 21?
Yeah. Forgive me. Now, I'm looking at your last sentence, I guess, of the response that begins "since." You see where I'm talking about?
Yes.
Now, that explanation doesn't address what physical hardship prevents the developer from complying with the ordinance section, does it?
Well, again, when you asked it the last time, the idea of the road not extending beyond North Guthriesville Road or beyond Horseshoe Pike is a physical limitation, but that's it.
Okay. Does that section, that explanation that you gave Does that justify a violation of 350-26? To the extent that you're reducing the ordinance, which sets the minimum standard and the requirements for promotion of public health, safety, and general welfare?
It's part of it.
So you don't think that that's a modification, or strike that, you believe that's a modification that's consistent with 350-26? Your response?
What do you mean by modification?
Well, what you're proposing here, as I read it, is to say that this violation of 350.33B is okay because there's a stop sign, et cetera, et cetera. And 350.33B has very specific requirements. And 350.26 says they're the minimum necessary for safety. I'm asking you, where in your explanation do you justify why reducing below those minimum standards is okay?
It's the entire response, not just that one sentence that you're talking about.
And that justifies, in your opinion, going below the minimum standards set forth in 350.33.
In my opinion, I support the waiver based on that discussion.
Okay. May I just have a minute? Now, just one point of clarity, since you brought it up. You're not a road designer, you're just a road reviewer, correct?
I'm a traffic engineer. So
Not a road designer, not an engineer.
I don't specialize in highway design, if that's where you're getting at. I'm a traffic engineer. I do provide opinions and criteria, recommendations for intersection and highway design.
But like Chirag, you don't design roads.
There are certain aspects of highway design that I do not provide, but there are other aspects that I do.
Well, I'm not asking about a highway, I'm asking about a street.
Highways, streets,
Well, I asked you a series of questions today about various sections of the ordinance and compliance with them, and your answers were to the effect, as I understand it, that you really couldn't address the issue because you're not a designer.
that's not what I said.
Okay.
I said, I am not the designer of this plan. Mr. Chirag is. Mr. Thakur is, I'm sorry.
I see.
He's the designer, I'm the reviewer in this, but that doesn't mean I'm not a designer.
Okay. So let me ask you then, in your capacity as a designer, looking at that blank piece of property as it stands, if you were asked to design a complying road, is there anything that you know sitting here today that would prevent you from being able to do so because of the land itself as it appears?
Objection.
Sustained. He's asked it and answered it several times.
Nothing further. Thank you, ma'am.
Mr. Kaplan?
Sorry,
Yeah.
I think
I thought you already asked Mr. Heinrich all your questions.
I haven't asked him a single question. No, he did not.
Okay. I mean, it makes more sense to have Mr. Kaplan respond to the questions Mr. Prince asked, in my opinion, but that's, I mean, that to me makes more logical sense.
But then Kaplan's going to get a second bite.
All right. Go ahead. Mr. Kaplan, are you comfortable with waiting until Mr.
I'm fine. I think it would make sense if I asked Andy my questions because they relate to what
I agree.
Mr. Prince
I agree.
asked.
Please proceed, Mr. Kaplan.
I agree too. Makes more sense.
Mr. Heinrich, the first questions I'm going to ask you are really background with regard to the questions that Mr. Prince asked you about the Section 350-37, which is number 26 in your letter.
Which is Exhibit B31, a letter of December 7th, 2018, from Mr. Heinrich, addressed to Scott Pearsall.
And this talks about, in general, about that there were turning movement counts were conducted pursuant to a traffic signal report that was last revised in December of 2016. You with me?
Yes.
Okay. My understanding is that PennDOT has established the location of a series of traffic signals along this section of the 322 corridor. Is that correct? Or do you want me to get into the specifics?
I don't know what you mean by PennDOT has established.
Okay. PennDOT has approved a traffic signal at Bollinger and 322, has it not?
Yes.
And,
Well, I'm not sure if the final design has been approved yet, but it's known that a signal will be installed. They've approved the warrants.
and they approved the HOP for the residential development on the Waters tract that is directly opposite Bollinger, is it not?
Yes.
And that design at least contemplates a traffic signal, does it not?
Yes.
And if it hasn't, and if the traffic signal permit has not yet been issued, it isn't because it won't be, it's just that the plans may not be done at this point.
Yes.
Objection, Your Honor. There's no way he can possibly answer a question about what might occur. It would require an assumption and speculation.
Sustained.
He answered the question.
Strike it, but I mean, parrot it. Your objection's noted.
Now, there is also an existing traffic signal at, I think it's the intersection of Hopewell Road and 322. Is that correct?
Yes.
And there is also a third traffic signal that's presently located at the existing BVA entrance along 322.
Yes.
Correct? And what has been proposed in this application is to move the light that is at the BVA intersection to the new proposed connector road, correct?
Correct.
So is it fair to say, and let me go one step further, in connection with the Applecross development, Pulte has either made or is making certain required improvements along the right-of-way of 322 between Bollinger and Hopewell, is it not?
Objection, if he knows.
Yeah, if he knows, he can answer it.
Are you referring to the improvements that are going in with the intersection upgrade at Bollinger, or somewhere else in between.
It's my understanding, well, let's take the one you're just talking about. There are improvements to 322 that are being made in connection with the traffic signal that is to be installed at Bollinger as a consequence of the development of the Waters residential development, correct?
Yes,
Pulte, as a consequence of having developed the golf course community, has made or will make certain improvements to 322 heading toward Hopewell Road.
Objection, madam.
Isn't
First
that
of-
correct?
Objection,
What's the
madam.
basis for the objection?
It has no relevance to the issue before us, what Pulte does or doesn't do.
Why-
And,
Go ahead, I'm
and
sorry.
secondly, it calls for him to speculate about something that there's no evidence he has any knowledge of.
Overruled. He's the township engineer. He's reviewed all of those applications. He's involved in all the intersection improvements along 322 as it relates to those. If you know the answer to the question, you can answer it.
there are improvements proposed along 322 in connection with that development.
So we've got a light set at Bollinger, we've got a light set at Hopewell. There are improvements along the south side of 322 because of the development of the golf course and as a result of the development of the Waters residential, correct?
Basically correct, yes.
And there are improvements that will be made to the north side of 322 as a consequence of the development of the Waters residential property. Isn't that correct?
Well, between the Applecross development and the Maple View development, that the intersection of 322 and Bollinger will be upgraded, including the installation of a signal.
And the plans that have been prepared for the installation of the light at the proposed connector road, both those plans that were submitted to PennDOT and those plans that were submitted to the township, coordinate the improvements, the traffic signal, and the improvements to be made by Carlino with the improvements that have been or will be made by Pulte and/or the developer of the Waters residential. Isn't that correct?
The development that goes in last will be responsible for tying the two improvement projects together, yes.
And at this point, the Carlino development will be the last, will it not?
It seems that
Objection.
way.
How can it be the last? We've heard testimony about the project immediately across the street that's still in the preliminary planning stage, which fronts on 322. So
But but it's overruled because he's talking about Maple View and Pulte. You're talking about the NV Homes proposal.
he's talking then only about the two
That's what
developments?
his question was relating to. Yes, it was
Okay.
yes.
So the purpose, now I thank you for clarifying that. Now, I'd like to turn to the study that was prepared in December of 2016. It is my recollection that as part of the 2016 Carlino application, you recommended to this board, or the prior version of this Board of Supervisors, that Carlino update its traffic signal analysis for the purpose of determining what the proper timing of the lighting cycles would be. Is that an accurate statement?
The signal timing and phasing for the proposed signal, yes.
And did I say it, did I give the right reason why you recommended that?
Simply stated, I mean, it's a little more complicated than that, but simply stated, that's basically correct.
So you wanted Carlino at that time to take new actual counts of the traffic on 322 and then add to that the proposed traffic, background traffic, and complete that study. Am I saying it correctly?
In a nutshell, yes.
Okay. And I think that what you said before was that the traffic studies that Carlino had prepared in the past had assumed certain background growth or additional growth because of then proposed developments which have not come to pass. Is that correct?
In some cases, yes.
And I take it that it's your opinion that the I'll strike that. Let me go on to another issue. Okay. Oh, sure.
Take a quick.
Jen, how much time do you need? Okay.
Okay, we're all back, yes? Okay, we'll go back on the record. Continue, Mr., did you answer the question, or did we stop? I can't remember.
I think we stopped.
Okay.
I'm giving you a copy of your letter to Scott Pearsall dated June 22nd, 2010. I've marked it Exhibit A3.
We had previously called them Carlino, at least Carlino 1, Carlino 2. So could this be Carlino 3? Okay.
Now I'm going to give everybody a copy of a plan that I've marked as A4, but I guess we'll call that Carlino 4.
Thank you.
Mr. Heinrich, the plan marked,
Excuse me, I'm confused. There is a Carlino 4 in the book that was handed out earlier,
that whole book is A2.
2.
Yeah, we made that whole book A2.
Okay. Got it. Thanks.
Mr. Heinrich, A3 is your review letter of a strike that. A3 is your review letter of the then current version of the Carlino application for the development of what we've called the giant shopping center, is it not?
Yes.
And your letter is dated June 25 of 2010.
June 22.
Okay, I'm sorry, I read where it was received, you're right, June 22, I apologize. And in that review letter, you were commenting upon the plan that is Exhibit A4, which was dated 5/19/2010, correct?
Objection. This plan and this review letter relate to a plan that at this point is 9 years old and has nothing to do with the plan that is before you. It has no relevance.
I think I agree with that, and so there,
Wait,
Mr.
wait.
Kaplan, how is it relevant to this proceeding?
Very relevant to this proceeding because Mr. Prince asked Mr. Heinrich repeatedly whether or not he was the one who required or suggested that the road be moved to its current configuration. And this letter is evidence with regard to Mr. Heinrich directing the relocation of the road to the current location.
Okay, well, I would agree then that that's relevant if this letter says that, so the objection's overruled.
But, Madam, you say if it says that, but you didn't look at the letter, and
Mr. Prince, it's
we
been
go again.
overruled.
it is consistent.
It's
with Ms.
overruled, you can answer the question. If it's relevant,
Saying it is relevant.
If it's in there.
Do you know what my question was?
I think you were just asking about the date, whether this letter was relative to reviewing this plan.
Exactly.
Yes, I believe so.
Okay. Now, and this plan shows the proposed road some distance away, 75 to 125 feet away from the boundary between the Carlino property and the BVA shopping center, doesn't it?
I don't know about the dimensions per se, but it's pretty close to that, yes.
And to make it more clear, and in between the BVA western boundary and the connection to 322, there's a bank pad, is there not?
Objection. Madam, I'm going to renew my objection. This is a reference to a plan that was never pursued. This isn't even the preliminary plan that was reviewed in 2010.
That's not what he's using it for. Objection overruled.
Mr. Heinrich, could you turn to page 3 in that letter, paragraph 8, under the title Preliminary Subdivision and Land Development Plans. Do you see that?
Yes.
Item number 8 reads as follows. The alignment of Brandywine Village Drive should be shifted to intersect Horseshoe Pike, paren US 322, to a point approximately 120 feet east of the existing proposed location. The drive-through bank pad can then be flipped to the other side of Brandywine Village Drive. Did I read that correctly?
Yes.
Is that your direction? Is that your statement in paragraph 8?
Yes.
Seeking clarification. Can you tell actually from Carlino 5 what the distance is from the center line of the road that's shown on that 8.5 by 11 sheet and the BVA property as compared to the distance from the center line of the proposed connector road on the plans that are currently before us?
You mean the actual down to a foot, or
Yes,
what?
down to a foot, sir.
That I cannot do. It looks substantially the same as that plan.
But you said exactly the same, and that's where I'm trying to get clarification. because-
you're putting words in his mouth. He never said exactly.
I'm sorry?
He never said exactly.
Mr. Kaplan said exactly, and he said yes.
No, I didn't.
You can clarify on your answer.
I'm trying to get a clarification, that's all, sir.
Well, I think we ought to go back to what I actually asked before we do this. I don't believe that I said exactly. I said the same location.
This is cross.
The records, but the record stands for itself, so they can read the transcript to what exactly was stated. So,
I'm asking you for clarification. Is it in the same location or not?
It's substantially in the same location. Whether it's down to the exact foot, I couldn't tell you.
How many trucks have you been told the proposed giant shopping center will have in, as part of your review of the traffic situation here?
I believe one truck every other day.
And one truck every other day, is that where you developed the phrase occasional truck in your review letter?
That's substantially part of it, yes.
No, not part of it. It's very important for all of us to understand, sir, what your conception of an occasional truck is. That's why I asked you first, how many you were told about. So
Well-
it's one, excuse me, let me finish my question, please. You just said that you were told one truck every other day, just so I make sure I'm right. Is that what you said?
That's what I just said, yes.
Okay. And do you equate that one truck every other day with occasional, the term occasional, which you used in your report?
Yes.
Thank you. Would you be surprised to learn that BVA does want a rear entrance to its shopping center? And in fact, we spent almost a whole day in Philadelphia trying to reach an agreement on getting that rear entrance.
Objection.
Were you
That's,
aware?
that's sustained,
Objection.
you can't bring that in.
Are you aware that BVA does want a rear entrance to the back of its shopping center, Mr. Honey?
I'm not aware of it, no.
And if you were aware of it, well, let's do it this way. Would you please turn, sir, to your report, which is B23, page 2, item 3.
B23,
B23, I think it's your November 5th.
I got the report now. Would,
Okay, page 2, item 3. You have it in front of you, sir?
yes, I do.
All right, now, in your original comment, you requested that the developer show turning templates for a proposed rear entrance to BVA Center. Am I correct?
Yes.
And the response is, when you have a response in this letter here, where it's in bold says response, is that what the developer said to you in response to your comment? Just so I'm clear.
Yes.
Okay. So they said that there's no agreement to the proposed connection road, and therefore they didn't actually show you the turning templates that you had asked for. Am I correct? Are we together so far?
Yeah, we discussed this last week. The original plan that I reviewed showed lines on the plan as if the driveway would be connected to the rear parking lot of the BVA shopping center. And that, at the time, or it was explained to me that was not correct, that the driveway would not be extended into the property. It would only be extended to the property line.
I understand, but that wasn't my question. Let
Oh,
me ask the
sorry.
question, please.
Okay.
Your comment says satisfied, and I'm trying to understand how it was satisfied when you asked to show the turning templates and they didn't show them. Can you please explain that?
Well, as I just mentioned to you, the original plan that I was shown appeared to show that the driveway would be extended to connect to the parking lot, and that is not the plan. So the plan has been revised, I guess, that shows that the driveway is only, the curb returns are only being provided to the property line, and any future extension presumably would be done by the adjacent property owner to make that connection. So that part of my original comment was satisfied. And then I also add that to ensure that the right turn corner radius be provided to accommodate a truck turn for that modification should it happen in the future.
If in the future a rear entrance is then provided, and the design or location of this road does not allow for an appropriate truck turning movement, don't we have a problem potentially because you've now accepted their representation that we didn't agree to a rear entrance?
If it was found that the radius was still not adequate, it would have to be adjusted, or it could be adjusted.
And if the road, well, how could it be adjusted if the road is fixed based on some of these other reductions in turning radii because of the location of the proposed road? You can't fix a radii once you have the fixed location of the road on the ground if it's too close, am I correct?
Why not?
Well, you tell me. You testified a number of times that as a result of the location of the road, there wasn't enough room to adjust the radii. In fact, when we were discussing this previously, you used that very same testimony to support a reduction from 30 degrees required by the Saldo to the 25 degrees requested by Carlino. I'm just trying to understand the testimony and make sure that I'm understanding the consistency of it.
Well,
So if you have
if
a
I
fix-
understand your question, you're mixing apples and oranges. Sticking just to this one driveway, if that right turn corner radius had to be adjusted and BVA wanted it to be adjusted, that radius would then be in public right-of-way. So I don't see anything preventing BVA from making an adjustment if they deemed it necessary to accommodate their trucks.
In the location where this proposed road is on, if you would turn, sir, please, to Board 3. Let's look at sheet,
The large set is right there up on the table, if it's helpful to look at the larger set.
if you look at sheet 5, please.
Hey, Scott, do you mind flipping that to page 5?
You have it in front of you, sir?
I believe so. Is this the one drawing number, is this drawing number 20.00?
That's what I have, yes, sir.
Okay.
So, focusing again on my questions regarding the rear entrance to BVA, or the proposed, let's call it a curb cut, I guess, for there. As I look at this drawing, the last date on this drawing is revised 10/16, correct?
Yes.
And they didn't adjust the area that's shown there for that rear possible entrance. So my question is, looking at this plan, is that the plan, the same configuration that you looked at when you made your original comment number 3?
The location is substantially the same. What's changed is the extension of the driveway across the property line is shown in dashed lines as opposed to solid lines, which was previously shown to make it look like it was actually going to be constructed as part of this plan.
All right, so the only difference then would be a solid line instead of a dashed line.
I believe so.
And the radii that's drawn on here, which is the one, that's the same, is it not, sir?
I believe so.
I have no other questions. Thank you, Mr. Hyman.
Mr. Kaplan, do you have any?
I have no further questions.
Okay, Mr.
I have some questions on redirect. Mr. Heinrich?
You called him as of cross, number one.
I have some questions in light of Mr. Kaplan's
Okay.
questions.
He didn't, oh, you're talking about his original questions.
I'm sorry,
You're talking about his original questions?
Mr. Kaplan's questions.
As a result of the questions he asked because of
Yes.
you. Go ahead.
Yes. Mr. Heinrich, would you turn to Board Exhibit 6? It's in your big book.
And this
You
is,
still have in front of you Carlino's Exhibit 5. That's the MOU. You still have that?
Looking. Yes.
Now, would you please go to paragraph 8 that Mr. Kaplan questioned you about?
Hey, wait, I didn't ask him about this letter.
you asked about the MOU. He's on Carlino 5.
I thought he said 6.
Well, he first went to B6, and then he referred back to Carlino 5, so.
Mr. Heinrich, you have paragraph 8 of the MOU on page 8 of the MOU?
Yes.
You see the last clause of that sentence? The sentence is, "The preliminary final plan shall be in substantial conformity with the final plans approved by the board on August 7, 2011." And then there's an exception. Would you read out loud what it says about the exception?
With the exception of modifications necessary to bring the project into compliance with section 350-34, period E of the SALDO.
You see any other sections referenced there?
Not in that
that are-
paragraph.
I'm sorry?
Not in that paragraph.
Okay, so that paragraph doesn't reference any other exceptions that are allowed for the plan to be in substantial conformity with the final plan of August 7, 2011, correct?
Appears to be what it says, yes.
Now, would you please look at B6?
E6?
B is in boy, board 6 in the big book,
Yep.
okay? Now, I want to ask you a couple questions about this. First of all, just for identification purposes, even though it is a board exhibit, turn to page 4. And you'll agree with me that this was submitted by Arna Engineering, by Chirag Thakkar, who's actually the gentleman sitting behind Mr. Kaplan in the brown coat, correct? Yes. Okay.
I'm
Now-
going to object. This is beyond the scope of my cross-examination.
Well, he can show an offer of proof.
Well, no, well, if I may, redirect after cross-examination is supposed to be very narrow. It's supposed to be limited to that which was raised on
Let's
cross-examination.
hear his question before.
Mr. Kaplan has attempted to argue that the MOU has fixed the road because this paragraph says that therefore this is binding on the township. I have argued in the preliminary comments submitted to you, which is an exhibit, a board exhibit, that that is not the case, that the MOU is not binding, that aside from it being an illegal agreement, the plan submitted is not in compliance. I am attempting to show, in response to the testimony he elicited from Mr. Heinrich, that in fact, the application submitted and the request submitted that appears in B6 have substantially more variations, changes, and alterations than is allowed under the MOU.
But I don't think we need Mr. Heinrich to testify to that. I think the board understands, based on the correspondence and all the board exhibits submitted, there are many waivers requested. So if that's the point you're trying to make, I don't think we need Mr. Heinrich to confirm that. I think that the documents speak for themselves. These are in the record. There's waiver request letters from both the applicant's engineer as well as the applicant's counsel. So
But let me
that
speak
goes without stating. The objection is overruled.
But
No problem.
That's okay. Are you okay? So this hearing will be ended today due to sickness. We will reconvene on February 21st, which is a Thursday, at 9 a.m. We will conclude that day at 4 p.m. We will, if necessary, reconvene on Friday, February 22nd at 9 a.m., and we'll convene at 3 p.m. that day. Please exchange whatever reports you have to,
Mark, a copy of the report that Mr. Ulrich brought down today. I'm going to give that to him now before he leaves. And I'm going to request, consistent with his protocol, that we receive, if he's going to have any response to our report, I'd like to receive his written response no later than 1 week before the 21st.
and can the township also have a copy, please?
Yes?
Thank you.
Today?
Motion today?